Good morning and welcome to today's webinar, Trustee Selection, How to Choose the Right One for You, presented by Elville and Associates President and Managing Principal Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work, you as the attendee are on mute. However, you have the voice. When you have questions, please note them in the questions panel in the right-hand portion of your screen, and we'll take time throughout to address them. You received the presentation yesterday from me by email ahead of time for your convenience to take notes on it if you wish. And as always, for CFPs and CPAs on today's webinar, you may receive 1.5 continuing education hours for attending. Now, per my attendance records requirements, please email me your board ID, and for CFPs as well, the last 4 digits of your social security number as soon as possible, so I can submit my required reporting to get your CE approved. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out this simple survey to offer us valuable feedback about the presentation. It's also a great time to request a consultation with Steve for any planning needs your family and you may have. And I'll also remain on the webinar afterwards for a few minutes if you have any remaining questions. So very briefly, an overview about our firm if you're not familiar with us. We were founded, actually let me share my screen so you can see our little presentation here. We were founded in 2010 in Columbia by President and Managing Principal Stephen Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys and 12 staff members in 5 locations. Our mission, as it always been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We focus a lot on education here at the firm, as you probably know. We do that through our planning processes with our clients. We offer over 100 educational workshops and webinars here at the firm in the communities we serve each year, and also by way of our accredited client care program. We're the only firm in Maryland and one of only 75 in the country to be accredited through our client care program through the program in Boston, Massachusetts, the Client Care Academy. We also focus on the ideals of client education, collaboration, and compassion every day at our firm, and you should expect nothing less from us anytime that you work with us. A little bit about Steve briefly. Steve's work as an attorney for the past 20 years has been focused in elder law, special needs planning, and estate planning. He is a member of the National Academy of Elder Law Attorneys, Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. And he works to bring a peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. He's a very seasoned speaker, presenting at about 75 webinars and workshops every year, and this year was named to the Maryland Super Lawyers list for a 5th time in 2020, so congratulations to Steve again. And with that, I will go ahead and turn it over to Steve, but first we're going to get started with a very brief poll, and I always like to do that to get an idea of who we have on the webinar today. So I'm going to go ahead and launch this poll. Just give me a second here. There we go. And the question that we have today is, what has brought you to today's webinar regarding trustee selection? So please select the response that applies to your current situation. And I'm going to go ahead and launch that. And the responses are, I'm a grantor. I've established a trust before. 2, I've been or am a trustee of a trust. 3, I'm the beneficiary of a trust. 4, I'm considering establishing a trust. Or 5, I'm an advisor here to better serve my clients by learning. So just select the response that best applies to your current situation, and we'll get an idea of who we have joining us today. See the votes coming in a week and a half before Election Day. Vote today and vote on November 3rd. So we'll just give it a couple more seconds here. And it looks like with the majority of responses in, it says 46% I'm the grantor, I've established a trust before. 23% say I've been or am a trustee of a trust. Nobody said I'm the beneficiary of a trust. 8% said I'm considering establishing a trust. And 23% said I'm an advisor here to learn to better serve my clients, which is always great to see. So thanks to everybody for being here, and welcome to newcomers. So with that being said, I'm going to close the poll. I'm going to go ahead and turn the screen over to Steve, who you've come to listen to. And welcome, Steve, and you should see that pop up so you can share your screen.
Thank you, Jeff. I do see it, and I'm going to make sure there's nothing on my screen here that's in the way. So I'm just going to make some adjustments. Thank you very much, Jeff, and good morning, everyone. And good and happy Friday to everybody. I really appreciate you taking the time on this Friday morning to spend some time learning and how to make a trustee selection and what is best for you and or beneficiaries in that regard. It is a very busy Friday, so I'm going to be brief in my comments and get right into the material. But it's my privilege to be here this morning and to once again have an opportunity to speak with you, to educate. And one of the things our firm is known for is education. But another thing we're known for, if you're not aware of this, is we're big believers in giving people, giving clients, giving family members a path forward. So we not only educate, but we take great pride in giving you a path forward. This is a direction you can take. These are the solutions, and not just purely academic information. So that's my goal this morning, is to educate you, and I'm hoping you have a great Friday and weekend ahead. Now, with that said, you may have questions, and Jeff is a great moderator. And if you didn't know this, Jeff is very expert in his approach, and he will field your questions if you have any. He'll interrupt me if I don't give enough time for questions. And so just be assured, you help us a great deal if you will be proactive during the discussion. If you have questions, don't be shy, don't be afraid to ask these questions. We're going to take a couple of breaks in the presentation, and we're going to go for maybe an hour to an hour and a half. I don't think we're going to be longer than that, and power pack information here to give you a frame of reference and a foundation. The other thing I've noticed, Jeff, this morning is the syncing of our sound and video seems to be a little bit off, a little bit slow. So if you're watching what I'm watching and it looks like I'm talking but my mouth isn't moving fast enough, that's something I noticed with Jeff. It's something I'm noticing with me right now. So I apologize about that, and I hope the speed of things will pick up and things will be more synced. So sorry for the slow appearance here of the sound versus the video. Hopefully that will correct itself during the presentation. Also, if you have any technical difficulties, if you're experiencing anything, you're not hearing us, please let Jeff know, and that will help us a great deal. So with that said, I'm going to minimize myself on my screen and get to the presentation here. And Jeff, I'm just testing my control, and it looks like I do have control. So with that said, welcome everyone, and we're going to get right into the material now. So we're going to discuss today what is a trustee and what are their responsibilities and what could be more important as we are in this very different time in the world. Obviously, history shows us there's all kinds of different events over time in the world, but it seems like our time in the world right now is very, very different than it was just a few years ago. Lots of changes, all the political situation, all of the health situation. What could be more important in estate planning except trustee selection, and what are their responsibilities? What are the types of trustees and their characteristics? What are the advantages of certain kinds of trustees, whether they're family members, what we would call interested trustees versus disinterested or independent trustees? What is the perfect trustee, if there is such a thing out there? Why is trustee selection so important overall, other than what I just mentioned? What is trustee succession in the plan when you're doing planning, or if you've already done planning, which many of you say you've already established a trust, as you go through life to possibly amend or update that trust, what is trustee succession in the plan design, and why is this so difficult? What are the roles of trustees in wills and trusts, just in general? What are some of the reasons to consider a corporate trustee? So we work with many corporate trustees. In the past, it seems like this was not so prevalent, but I think there's an increasing role potentially for the right situations for corporate trustees. And why should you be concerned about the future risks of successor trustee selection? And in other words, when successor trustees take over in the future, what is the risk involved there? And what should you do to make sure you're minimizing that risk? All right, I'm trying to move the screen forward here, Jeff. Here we go. So what is a trustee and what are their responsibilities? All right, so getting to my proper screen here. The role of a trustee is pretty obvious. They have to administer the trust. Now, we're going to be intentionally redundant today because the idea I want to convey here is the idea of education. We want to educate you. We want to give you some nuts and bolts to walk away from this presentation that you'll remember. And one of the things I've learned over time is that sometimes we leapfrog over certain concepts that certain people don't really grasp, and we just assume that they do. So I'm going to be intentionally redundant throughout here. So the trustee's role is to administer the trust, follow the terms and provisions of the trust. Would it surprise you that some trustees, and I'll say many trustees, never really take the time to fully read the trust? They're administering a trust that they've only partially read, or they read it 5 years ago and have never read it since. They have to follow the terms and provisions of the trust. Keep accurate records. This is very important. What if a trustee is called to account, which they should be called to do? And that is the next bullet point. The trustee has to account to the beneficiaries of a trust. Believe it or not, as you're going to see, beneficiaries are entitled to information. And if they ask for an accounting, they're entitled to it. The trustee has to make distributions in accordance with the terms of the trust. I think that's common sense. Some of those distributions may be mandatory, like the trustee has to distribute mandatory income, or they can be discretionary. The trustee could distribute discretionary income or principal of the trust. The trustee has the job of really making trust investments. Now we're gonna look at that and say, well, most trustees probably shouldn't be doing that because they're not really professionals. But when I say their job is to make trust investments, their job is to make sure that they are hiring the right professionals, the professional money managers, the professional financial advisors to make their appropriate investments. Communication with beneficiaries, this is huge. How many trustees don't communicate with the beneficiary, don't stay in touch with the beneficiary, do not understand the needs of the beneficiary? This is a big problem that needs to be addressed right up front when a trustee takes over. The trustee has the job of making sure that all tax filings are complete. That is something they can also farm out and not necessarily do themselves, and generally speaking is not advisable to do themselves if it's a non-professional trustee, to make sure they're hiring a CPA to make sure those tax filings are done. And to manage the assets, taking into consideration the taxation of trusts. Trusts are taxed in a different way than individuals. And for those of you who may not be familiar with that concept, that is beyond the scope of today's discussion, but just safe to say that trusts have their own rates of taxation and trustees must understand that to minimize trust income tax. Now let's review some basic definitions and trust basics. So again, in the spirit of being redundant for your benefit, what is a trust? Well, one definition is that it's a relationship that springs from an agreement between a grantor. Jeff mentioned this in the beginning. A grantor is a person who creates a trust. In the old days, or 25 or 30 years ago, this might be known as a donor or a trustor, and this is a person who establishes a trust, and the trustee who actually provides for for the benefit of the beneficiary of the trust. And the parameters and roles and responsibilities of the trustee are described within the trust document. And you'll notice here in parentheses, and applicable law. So we want to look to the document first, and then we want to look to the applicable law if necessary. And who are these parties again? So the settlor or trustor or grantor, as we now call it, the person who establishes the trust, the trustee, the person who accepts this role and accepts the management of the trust property for the benefit of the beneficiary. And who is the beneficiary? Is the person or persons, could be multiple beneficiaries, for whom the trust property is intended and how that is provided for in the agreement. Now, as we continue the review of trust basics, we have revocable trusts, trusts that can be changed, which we're going to define here, or irrevocable trust, trusts that in theory cannot be changed, but in reality, even an irrevocable trust can be changed in today's world. And we'll talk about that a little bit. So what is a revocable trust? It's a trust that may be amended or modified or revoked at any time by the grantor. And many people have this question, what is a revocable trust? It sounds awfully complicated. Well, my simple answer is we have the possibility in basic estate planning of a will-based plan, or a substitute for a will, which is a revocable living trust. And in my view, a revocable trust is nothing more than an alternative to a will. It's a contract that a person creates, and that's why they can modify or amend that contract at any time. And you'll notice here the taxable income of a revocable trust is paid by the grantor. The taxes on income are paid by the grantor. It's called a grantor trust, which we're going to talk about in just a few minutes. So a revocable trust, the taxes are paid, the income is attributed to the grantor, the taxes are paid by the grantor because it's revocable and the grantor has control of that trust. Now, an irrevocable trust generally cannot be amended or modified or revoked except through court intervention or agreement of the parties, or through the use of a special independent trustee or a trust protector, which we're going to talk about all those concepts, or if the trust is decanted. So decanting is a way of changing a trust completely from one trust to a brand new trust. And we'll talk a little bit about decanting if I have time today. So again, we're just getting through the initial slides here to lay the foundation of some basics. So what are the common trusts today that are being implemented? And many of you are very familiar with this. Again, this is a review of very much basics. So a traditional revocable trust, what is it? Well, we talked about it being an alternative to a will. We talked about it being something that is taxed to the grantor. But here, the main purpose, as you'll see here, is for management and the avoidance of probate. A revocable trust does not avoid creditors. It does not reduce estate taxes. It doesn't do anything like that. It is a probate avoidance device. Now, with that said, there's the issue of privacy. In theory, this is a much more private approach. And in theory, the cost savings are much greater at death. And this assumes a lot of things. This assumes that the grantor was a good student and was on calls or videos like this and during their lifetime. And they actually worked to maintain and update their planning over time. Jeff mentioned that Elville and Associates is the only law firm in Maryland that has a client care program certified by the Client Care Academy. One of the reasons we did that is we want to encourage people to update. And when they update, such as a revocable trust update over a period of time, now we're going to have probably a lot of cost savings in the after death period. Now, what are the disadvantages of a revocable trust? Well, there is possibly some increased cost at the beginning, and then there's a little bit of confusion at the beginning of getting all the assets aligned. And that is a really big issue. So the more we can do during our lifetime to make sure that assets are properly aligned in trusts or to trusts at death, the easier the job of the trustee is going to be in the future as we think about who the trustees are going to be. So asset alignment is a huge issue with trusts, especially revocable trusts. Now, there are also trusts for at-risk beneficiaries. So let's say we are protecting a person from themselves, from their own spendthrift tendencies, or from their ability to not be able to manage things, or health issues, or maybe there are relatives who are exercising undue influence over a person, or maybe this person just generally has special needs. So again, the trustee holds property and uses the property for this person. And depending on what we're trying to do with such a trust, we may use dynasty trust type structure where the property remains in the bloodline and there's a tremendous amount of asset protection. All trusts such as these types of trusts are designed, and there should be a lot of design and time spent in thinking about how they should be designed. There are things such as beneficiary controlled trusts where the beneficiary is able to exercise a lot of control over the trust, but still enjoy asset protection. And this can be established through a revocable trust or a will. There are times when the beneficiary could be and maybe should be the sole trustee of their trust, and they can also be the beneficiary. And then there are times when maybe that shouldn't be the case. There are times when it's much better to have an independent trustee involved instead of a person being the trustee of their own trust or some related person being a trustee of that person's trust. There are things such as exception creditors. So no matter what we're doing to protect people in trust, there are things like alimony and child support, and of course, Uncle Sam, taxes, or the state of Maryland, where beneficiary control trusts, or what I will just say spendthrift asset protection trusts, do not protect against these types of exception creditors, but generally speaking, provide a great deal of protection otherwise. Now, we mentioned special needs trusts. This is another example of a common type of trust being implemented today. There are basically two types. There is the third-party trust. This is the kind of trust that is developed by people who are doing routine estate planning, where there's a spouse or another relative, a non-spouse, that has special needs. And that means that at the person's death who is establishing this trust, money is coming from that person or from other assets from other people, third parties, into the trust for that person. The disabled person is not actually receiving those assets, not actually becoming the owner of those assets. And the assets are exempt for public benefit purposes. In a self-settled trust, or what is called a first-party trust, that disabled person receives assets that they probably shouldn't have received. And then we have to take a different route, which thank goodness has been sanctioned by federal and state law, to basically be able to shelter that asset that the person has received that they shouldn't have received, with the disadvantage being that that kind of arrangement has a payback to the state of Maryland, generally speaking, or any other state that that person may be living in. So that is a first party trust. So we have general needs trust, I think is the best way to think of it, and we have special needs trust. And that is, I think, a very straightforward way of thinking about it. Now remember, again, the trustee is the person who is accepting property into the trust and managing that property for the benefit of the person, the beneficiary, and the beneficiary is the person or persons for whom the trust is intended to benefit, and so forth. The trustee decides how and when and where to provide for these benefits, and I want to make this distinction here. The trustee is going to pay assets either to the person or for the benefit of a person. So in other words, an example of paying an asset to a person is, let's say the beneficiary needs a new Apple computer. I'm just throwing that out there. The trustee could just go ahead and give the person $2,000 to buy that new Apple computer. In some circumstances, that might be okay. In other circumstances, that would not be okay at all. So the trustee would pay for the benefit of a person the assets of the trust, which means the trustee would simply buy the Apple computer and not give the person $2,000. So that's an example of using assets for the benefit of a person. Now, I'm just going to take a breath here and see if at this early part of the presentation, Jeff, whether we have any questions.
Thank you, Steve. No questions at this time.
All right, very good. Well, we're going to keep plowing ahead then. And now we're going to talk about grantor versus non-grantor trust. And I'm just going to stay on this slide for just a second. So remember that in the IRS code, there is something called the grantor trust rules. And this is basically the IRS code section 671 through 678, basically. And in this complex section of the code, it talks about basically the rules surrounding what happens when there's a trust and who pays the income tax. It also has to do with whether a trust is included in the estate of someone who has developed the trust. So that's a very simplistic explanation of the grantor trust rules, but let me get into it just a little bit more. We've already talked about a revocable trust. So a revocable trust is a primary illustration of a grantor trust, a trust over which the grantor has control of the trust, and the grantor can amend or revoke the trust at any time. It's included in the grantor's gross estate for estate tax purposes, and therefore the grantor pays the income tax on any income earned in that trust, just like they would if they had no trust. So a grantor trust is a trust where the grantor pays the tax. Now, a non-grantor trust is a trust where the trust pays the tax at the trust level. So let's talk about examples of a non-grantor trust. And I'll give you several examples if you're writing this down. So a good example would be a non-grantor trust is a trust at death. Let's say someone passes away and leaves a trust, and this would be an irrevocable trust, for a spouse, a child, niece or nephew, or other beneficiary. That is going to be a non-grantor trust. It's going to have a tax ID number, and that trust is going to pay its own tax. Now, there are ways for the trustee to deal with the fact that at the trust level, the highest tax bracket is going to be hit at a very, very early point, such as only $12,800 of income. And we're going to be at a current 37% tax. But there are ways of dealing with that by distributing out income to the beneficiaries and not allowing the trust to pay the tax itself. So this is a typical situation with a non-grantor trust. But another example of a non-grantor trust would be an irrevocable trust. So again, I'm just stop real quickly. Remember the grantor trust, the grantor pays the tax, very simple. The non-grantor trust, the trust pays the tax at the trust level. And an example would be a trust at death. Another example would be a lifetime trust, an irrevocable trust, such as a life insurance trust. Or there are other examples of non-grantor trusts that can be established. Now, the confusing part here is that there can be irrevocable trusts established during life that are grantor trusts. So for example, a life insurance trust is an irrevocable trust during life. It cannot be changed in theory, and it's designed not to be in the estate of the grantor, and yet it is a grantor trust. It can be drafted usually as a grantor trust where the grantor is paying the tax. Another example is a gifting trust. Let's say a lifetime trust is established, it's irrevocable, but the grantor says, well, not only do I want to make these gifts to my children or grandchildren during my life, I also want to pay the tax of that trust so that I'm giving an extra gift of the income tax liability. So basic thing to take away from this slide is there are two types of trust in general, the grantor and non-grantor trust. And we as trustees, or when we are thinking about trustee selection, we want our trustee to be educated about the tax ramifications of trust and whether the trust is intended to be included in the estate of the grantor or not. So this is part of the competency that we really want when we're selecting trustees. Now I'm going to launch into a discussion very briefly of the 2014 Maryland Trust Act, just one little aspect of the Trust Act, which was a very big deal, which talks about people being what is called qualified beneficiaries and whether notices are required. And prior to the 2014 Act, Maryland was not so good about really defining these kinds of things. And beneficiaries of trusts really were not entitled to certain notices. They were not entitled to information. So as you think about who is a trustee of your trust or future trustees, this issue of competency, do they understand and are they willing to learn what is a qualified beneficiary? What are the notice requirements that are required in Maryland? And the information that qualified beneficiaries are entitled to. They're entitled to a copy of the trust, annual reports. And I will say, for better or for worse, Maryland has made it pretty clear that beneficiaries are entitled to all information. There's really no limitation that I'm aware of. Now, there is a little bit of confusion. There is one part of the Maryland Trust Act that talks about a special representative that can be appointed to receive information for the beneficiary. And at first, this looks like that Maryland might be allowing what is called a quiet trust, like Delaware provides, where a beneficiary at a certain point is not entitled to information. But I think the research is showing that is really not what that statute is meant for. And even the person who is designated to receive information for a beneficiary is really responsible eventually to share that information with the beneficiary. So all that to say, beneficiaries in Maryland are entitled to information, and we have to, as trustees or our future trustees, understand that we have a responsibility to be transparent and provide information. And in all situations, that's sometimes not a great idea where we have certain beneficiaries, but that is the law that we have to live with. Now let's talk about the role of a financial advisor in establishing a trust. So as you think about who your trustees are, I want you to kind of think about, is my trustee going to understand that they have the right to hire agents? They have the right to hire a financial advisor. They have the right, and they should hire a CPA, and they should hire professionals to advise them and not try to do it all themselves. I have seen this happen, and it's generally not a good idea. So what is the financial advisor's role if our trustee is dealing with them? Well, the financial advisor is going to be very concerned about who are they taking instructions from? Who are they sending statements to? Are there going to be debit cards and checkbooks and so forth for the account? How do they make the trustee's life easy? Because what we're trying to do is keep costs down, right? So remember that trustees are entitled to commissions. So we want to pick a financial advisor who understands this and is going to make life easy. Funding the trust with in-kind assets. Let's say someone has died. The financial advisor now is going to have the responsibility for stepping up the basis of certain assets to the new fair market value and ensuring that everything is done in that regard so nothing is missed. The financial advisor is going to manage the portfolio, and the trustee that you select needs to understand this, and they need to be willing to be counseled. What is the goal? Recently, I was involved in a trust, and I'm still involved in a particular trust, where the trust portfolio, it grew over the last several years, as many portfolios have grown, but the trust allocation of assets is inappropriate. It's contrary to the terms of the trust, and it's also contrary to the actions of the trustee. So we want to make sure that the trust asset allocation as it's invested is in alignment with the terms of the trust and the goals of the trust. And the trustee needs to be advised that they have a responsibility. Now they're kind of turning that responsibility over to the agent, who is the financial advisor, and that person's going to keep the trustee, or that company is going to keep the trustee on the straight and narrow, to be a person who is who is investing as a prudent person. So this is extremely important. And the trustee is going to want to have in their file an investment policy statement. They're going to want to have that piece of paper that says, you as the financial advisor properly advised me, properly allocated the assets, and have helped me meet my fiduciary responsibility of how the trust assets are being managed. So that is a very big deal as you think about your trustees or even yourselves as trustees when you're dealing with financial advisors. The financial advisor needs to understand the cash needs of the beneficiary and what are the monthly expenses, what is the budget and so forth if it's appropriate for that particular trust. Now let's talk about trustee duties in general. So far we've hopefully laid the groundwork, and we are now having a kind of a good understanding of what a trustee is, what a beneficiary is, what the different types of popular trusts are, although we did not get into more exotic trusts like charitable trusts, residence trusts, and so on and so forth. But hopefully we've laid the groundwork. We've given you some clues as you think about and talk to trustees. And I highly recommend that you do that as you think through the possibility of who my trustees are going to be. Don't just think about it intellectually and look at materials. I strongly recommend that you interview trustees and get an idea of what they're going to do if you are incapacitated or if you have died. How are they going to take the ball and run with it, so to speak? What are they going to do on the ground for your beneficiaries? Or are their offices 300 miles away and they're not going to be close to your beneficiaries? How's all that going to work? So I encourage you to do that. Now, before I get into this slide, I'll just stop and ask Jeff. Jeff, do we have any eager participants that have a question? I see the sun is coming out outside.
Steve, no questions thus far. We do want to encourage those questions to come and know that they're out there. So maybe people are just looking for the button to click on that question panel.
Understood. Understood. Thank you, Jeff. So I'm going to take two things from Jeff's comments. One, this is a very, very educated group that we're talking to this morning. So I'm very happy to see that. And the other thing I'm taking away, Jeff, is that some people are simply tired from staying up and watching the debates. So if you have stayed up and watched the debates, you're excused, and you should definitely just relax as I continue through the discussion. All right, these three concentric circles here really talk about, I think in a nutshell, what we're looking for in a trustee as you think about trustee selection. And I often tease Jeff, as I just was now, about putting a picture on this page. Someday we're going to do that. And that photo that we're going to put up here on the right side of this slide is really going to be this perfect person that we're going to keep looking at photos until we find the perfect model, the perfect person, because that's what we're looking for here. Is there a perfect trustee? Do we have a trustee that's really going to stay in touch? So let's talk about advocacy. Stay in touch with the beneficiary, whether it's special needs or not. Even if it's general needs, and we have a beneficiary that has certain needs and needs certain benefits from the trust, are we staying in touch with that beneficiary, advocating for them, understanding what's in their best interest? And as we kind of go in the direction of someone who's disabled, which is not always the case, we want to understand public benefits. We want to promote their well-being and best interest. So advocacy, or what I would just say, staying in touch with the beneficiary as per your fiduciary duty or the trustee's fiduciary duty. Accountability. This is a person who needs to keep accurate records. How many trustees go along month after month after month or year after year and have never kept any records? They've never kept a current accounting. They've never kept the beneficiary informed. So this is out of compliance with their let's say best practices or the statutory duties. Now, one of the things I've seen recently as a trend, it could just be me, and it could be something I've just seen in my corner of the world, is that many trustees today will say, I'm not going to spend the money to provide an accounting, because if I do that, it's going to cost the trust money. Well, I think that there's, yes, certainly an argument to save the trust money, but I think a highest and best practice is to always keep an accounting and always have that accounting ready to produce if the beneficiary wants an accounting, or just as a general rule on an annual basis to provide an accounting. And financial investments, we just talked about that. The trustee has the responsibility to invest and to provide proper financial investment for the trust and proper allocation. And they need to understand taxation, and they need to understand that they can hire professionals, and they certainly should. So along all those lines, that is what we're looking for in a perfect trustee. Now, why is trustee selection so important? And I took a lot of time there to lay some groundwork. Well, trust can last forever. And let's just talk about that for a moment. Trust can last forever, and many trusts today are designed to last forever, meaning they are dynastical type trusts, or trusts that are multi-generational, okay? And forever is a long time. So in Maryland, for example, we have no rule against perpetuities. And the issue there is that we're very favorable jurisdiction for leaving trusts that can last forever, even better than Delaware or Nevada, I will go out and say. And a fun fact is that my last check on Nevada law was that a trust can only last for 365 years. So forever is a long time in Maryland, and we want to have layers of trustees, not only good trustee selection for the initial trustee, but layers of trustees and flexibility, as we're going to talk about on this slide. Trusts are more portable than ever. Let's say that a trust was in Maryland, but it needed to be moved to another state for some reason, or the beneficiary is living in another state. Well, the trust law can be changed, and many states are in competition for trusts. For example, our friends in Delaware, millions and millions of dollars come into Delaware for their Delaware trust laws and trust planning. Beneficiaries, as I mentioned, might not be living in Maryland. Maybe they were, or maybe they never did, and the trust may have to be changed because of the particular domicile of the beneficiary. Trustees have options. They can say no. We've had instances where clients diligently planned. They selected their trustees, and this does not happen all the time. It's happened a few times, but the person passed away, and then the trustee actually refused to serve. And so this is something that you have to keep in mind as you think through this. And I'll jump right to the bottom there. We have to build in flexibility for changing circumstances. What if the world changes as it did 8 months ago? What if the political situation changes? What happens if the tax laws change? So we're going to want to provide for changing circumstances. And there are ways to do that in the trust design. I don't want to skip over the issue of decanting, which I mentioned. So trustee selection is very important because decanting, which Maryland does not have at this point in time, but may have in the future, there are many states, I want to say more than 20 states, that have decanting laws. And the decanting laws in these states can vary. Some are very conservative, some of them are very aggressive and liberal. And decanting can be used for good purposes or bad purposes. And what we want to make sure in our trustee selection is that if a trust is ever decanted, and I will give you an example. What if a trust needed to be decanted either under Delaware law, which is right next door, or in Virginia, which is right next door, which has decanting? Or what if we needed the super decanting laws of Nevada or Alaska or some other jurisdiction? We want to make sure we have a trustee that is going to act only in the best interest of the trust and the trust beneficiaries and understands the possibility of these things. I'm not saying they have to understand all the nuances of these things, but they have to be a person who is willing to go and be counseled or advised about such things and understand that there are possibilities for changing circumstances. So the trustee selection process could be very easy for you, despite all of this information I'm giving you today. You may just have a mental checklist of your children, your nieces or nephews, friends, siblings, or other relatives, or perhaps a non-relative, which we're going to get to in a minute, that might be already kind of a foregone conclusion for you. And if so, and you know this is going to be the order of my trustees, I strongly recommend that you talk to these individuals and have them educated. Find materials, or come sit in our conference room, or come sit in our webinars. Get them to commit to this process, and take their responsibility seriously, even though you may already have this foregone conclusion about who these people or organizations will be. Now, an interested trustee, as I alluded to earlier, and I'm giving you a very, very general definition. An interested trustee is basically someone who is subordinate to you. This is a person that the IRS and the world of trusts considers to be a person who is not independent. This is a relative or a person who is just deemed to be somebody who might do whatever you want them to do, or whatever the beneficiary wants them to do, is what I'm trying to say, versus an independent trustee, such as a non-family member, a bank or trust company, or a financial advisory firm that has a relationship with a trust company. It could be a CPA, it could be an attorney, any kind of an independent trustee. Now we have some issues there to see when we talk about the differences. So I'm going to talk about that in just a second. But this kind of selection is best done during the review process or the design process. There's no problem if you have an existing trust and now you're revisiting, and that is exactly what you should do. You should be revisiting over time, because remember, when you kind of set a trust, set it and forget it, as some people have said in the past, if we do that, now we're at great risk, because over time things change. But if you design and maintain and update and educate yourself and review, you're going to make changes over time. And that's what's ultimately going to protect you and your family, or the trust beneficiaries over time. To sit, take the time to think and visualize what you want to happen. Now, Jeff, I can't remember if I have a slide in here about letters of wishes, but I'm going to go ahead and throw that in here because we're talking about trust design and trusts under wills and the design there. There is something called a memorandum of intent or letter of wishes. And if it's already in here and I forgot about it, I promise we will cover it again. But I don't want to forget it. As you're going through the design and the thinking process, we want to give you the opportunity, or you should be given the opportunity, to develop a letter of wishes. So you go through the trustee selection process, you do the very best you can, you review all your materials, you do the interviews, you do what you feel is best with professional advice, but you should also develop a letter of wishes, which is a set of instructions for your trustee. This is what you want for the beneficiary. It may talk about your goals and values. It may talk about problems that they could anticipate. And you speak to the trustee as if it could be a person who doesn't know anything about the beneficiary. And sometime in the future, this trustee is going to be referring to this letter of wishes. So the letter of wishes is basically a memorandum that can be attached to a trust. And if it's a trust that's still in progress, that you're still designing or reviewing and designing over the years, this is something that you can update along the way. Now, there could be conflicts between certain trustees, so you want to think carefully about that. In a few circumstances, siblings can be trustees of other siblings' trusts, but the vast majority of the time, that is not a good situation. We just talked about individuals versus corporate trustees. So let's talk about the advantages and disadvantages of individual trustees versus corporate trustees. The individual trustee that you may have on your mental checklist, I want you to ask yourself, is this person an interested person? Is it a family member, or is it an independent person? The interested person has to distribute assets pretty much along the lines of a very general distribution structure. And that's not as advantageous for the beneficiary as an independent trustee who could be charged with being able to distribute assets on an independent discretionary basis, which gives the individual beneficiary more asset protection. So part of this has to do with what level of asset protection do we want to provide? What are we guarding against? And sometimes it comes down to costs. But remember, even an individual is going to be entitled to certain trustee commissions, whether they are statutory as per Maryland law, or whether they are, quote, reasonable commission standard, which is the kind of the modern or contemporary standard that's used in most trusts today, reasonable compensation. We'll talk about this a little bit in just a few minutes, but corporate trustees generally have a schedule of fees, a rate of fees that has been approved by the Secretary of State. So there are certain advantages and disadvantages of individuals versus corporate trustees. For example, the corporate trustee arrangement, or the whether it's an independent individual or a corporation, that individual or corporation is usually going to account for the commissions and so forth that they receive as part of their fiduciary duty. And they are also going to prepare a tax return each year, for example. And that's why we have to be careful when we're interviewing trustees to determine what are the services that are being provided for the fees that are being charged. Now, the trust protector is something that I just simply want you to think about. If you've never heard of this concept, a trust protector, or what Maryland calls in the Maryland Trust Code, the trust advisor, the trust protector is a flexibility mechanism. I want you to think of the trust protector as a person, not an organization, because at this time, I'm not aware of any organization or corporate organization that would act as a trust protector. I want you to think of the trust protector as an individual who is a special fiduciary whose job is to further the grantor's intentions. So if the grantor's intentions are to protect a spouse or a child or grandchildren, or to have smooth administration, or whatever the goal is, and we should outline our goals in the letter of wishes, the trust protector's job is to make sure these things happen. And the trust protector has the power of amendment. So the trust protector can direct the trustee to do certain things that the grantor lays out within the trust. So for example, the trust protector would have the power to remove and replace trustees typically. And the trust protector would have the power to make certain tax changes to the trust if the tax laws change, or other administrative type changes. These are the general widely accepted powers of the trust protector, as in the IRS code, or the IRS world, I should say, and in the world of trusts and estates. So trust protectors do what? They add scope and they add flexibility over a long period of time to give the grantor more assurance that their wishes are going to be carried out. So the trustee selection process, in the trustee selection process, trustees have to understand that modern trusts might be drafted with a trust protector. It's not required, but we strongly recommend it in most cases. And the trustee may be charged with working with the trust protector on certain issues. And the trustee needs to understand that the trust protector has the right to direct them and actually tell them what to do. And some trustees don't want to be told what to do. Some trustees, like certain corporate trustees, don't like the trust protector having too many powers. So the design process and in the selection process, you're going to be thinking about the use of a trust protector and how the trust protector works with trustees. Most good corporate trustees understand that the trust protector is actually a good thing. And if the relationship is not working out between a trustee and a beneficiary, then maybe it's best that that trustee is not serving. And the trust protector has the power to remove and replace them. So this is something I want you to familiarize yourself with if you're not already familiar with the idea of the trust protector. Now, we just talked about interested versus independent trustees. This is a little bit more of an explanation on that. There are different standards of distribution depending on whether we have interested versus independent trustees. Different points of view for, family members or other individuals versus the corporate trustee. Some grantors don't want the family to have to deal with the issues of an administration or a long-term trusteeship of a trust for a beneficiary. And so they want the objectivity of an independent trustee, and they feel some comfort, a lot of comfort actually, knowing that if that independent trustee relationship or corporate relationship didn't work out, that the trust protector can make changes. There's different levels of oversight potentially, maybe swinging back to the advantage of an interested trustee like a family member. Maybe there's more oversight of the beneficiary with an interested trustee, but maybe there's more financial oversight with an independent trustee. So these are practical considerations that really have to be thought out. And in the design process or in the review process over the years, this is something we want to sit and have the time to think about. Jeff, I'm just going to glance at the clock here. We've been going a little less than an hour. I've been making good progress. Is there any questions at this point? Are there any questions?
Steve, yes, we do have some questions. Our first question comes from a good friend of the firm, and the question is, what is your thinking on co-trustees?
All right, thank you, and thanks for attending, and thanks for that message. So what do I think about co-trustees? Well, it's all dependent on the circumstances, of course. Every family situation is different. Every co-trustee arrangement situation is different. What if there are two interested trustees, two family members, let's say, that are going to serve as co-trustees? Well, first of all, we have to decide, are they going to act together as co-trustees only, meaning they both have to act together, or can one act independently? So most of the time it's going to be they have to act together, although there are circumstances where they would be given power unilaterally to make decisions. So that's kind of a design or family situation question. Another situation arises where a corporate trustee might be a co-trustee with an interested trustee, and that's an interesting arrangement where someone wants an interested trustee to be involved, but they see the advantages of having the investment capability and the help capability, so to speak, or oversight and other tax preparation capabilities of an independent trustee. So that can be a very interesting and very advantageous situation, and a lot of clients like that. And then there are times when someone just wants co-trustees for more assurance. For example, let's say in a revocable trust, there are pretty broad powers for gifting, powers for being able to do all kinds of things that the grantor could do himself or herself. And the grantor is a little bit worried that the sole trustee has all of this power, okay? So what we might do is design co-trustees to give the grantor more assurance that there's going to be another oversight. Now, with that said, when we have co-trustees, we have this possibility of what if the trustees don't agree? So there has to be provisions in the trust, and this is where the trust protector can come in. What if the trustees cannot make a unanimous decision, and what if there has to be a tiebreaker? So there can be tiebreaker provisions, or the trust protector can be a mediator, and so forth. But I think that's a great question. I like the idea of co-trustees in many situations. And one of the most interesting is when we have an independent trustee and an interested trustee as a co-trustee, but it's all situational driven.
Another question, Steve. Do trusts that are strictly real estate apply to what you are describing? Can you develop a trust solely for property?
Thank you for that question. The answer is yes, absolutely. So there are various types of trusts that can be developed just for property. So for example, like a residence trust, and we might call that a QPERT, a qualified personal residence trust, which is an estate tax planning device that many people might be looking at right now at the end of the year here with the potential for the estate tax exemptions to change. But on a more basic level, we have many clients that will say, okay, I am going to, if I pass away, I want this piece of property, this real estate, to continue in trust. I want it to continue in trust for my children. I have a house on the beach, or I have a house that's in the mountains. It's a second home. I want that to stay in a trust for the benefit of my children or grandchildren or some special purpose. Or I want it to be for the benefit of someone who really is not doing that well in life, and I just want them to have the assurance of a place to live. So yes, real estate can be in trust, whether they are asset protection trusts at death, whether they are special needs trusts where we want to leave a piece of property or a residence for someone to live in that has special needs, whether it's in a Delaware trust for really high level asset protection. Many, many different types of trusts can be designed just to hold real estate. I will point out that not all corporate trustees really embrace the idea of managing real estate in trusts. So most of them do, but there's a few that will say if real estate is in a trust, we are not going to be able to administer that. So just be aware of that. But that's a great question.
Another question from a good advisor friend on the webinar. Hi there, Don. Question is the advisor liable if the trustee tries to change the investment portfolio to one that is not in the best interest of the trust?
That is a great question. Hi, Don. I hope all is well. The answer to that is something I don't know if I would be definitive on, Don. For example, let's say that someone came to you and said, I'm a trustee of a trust, and I just want to make sure that I'm on the straight and narrow with my investments. The beneficiary is X amount of years old. Here are their needs. Here's the budget. Please give me an investment policy statement to cover me, so to speak, as a trustee, that I've fulfilled my fiduciary duty. So let's say you do that and you make a recommendation and they agree to it. And then let's say they come back and say, gosh, I want to change that allocation and I want to be super aggressive, or something that intuitively is not consistent. It's not consistent with the terms and provisions of the trust, and it's not consistent with their duty as a trustee. Then I think that my initial reaction, subject to your broker dealer, my initial reaction would be, you are not liable as long as you have documented your file, and updated the investment policy statement to say this recommendation was made, this is what the trustee chose to do, and I would definitely have that trustee sign off on something that says they understand that you've recommended this, but they're going in a different direction. And again, that may not be the best relationship either. So I definitely think you would want to cover yourself, as well as show that the trustee was deviating from what you would consider to be their duty.
Another question, we do have a couple more that came in quickly regarding the letter of wishes. If we write that letter, do we just keep it with the will locally, or do you need a copy of it as well?
Great question. So if we are your lawyers, we are one of the only firms that I know of that still keeps original documents. So if we have your original documents, then yes, we would want a copy of that letter of wishes, or a signed letter of wishes, a duplicate signed original of that, and we would want to attach that to your will or trust. And remember, that letter of wishes, if it's on a Microsoft Word format or something on your computer, it can be updated over the years and re-signed. But I agree with you that we should have a copy of that.
Okay, and this is from an existing client. Can you tell me what article or section the letter of wishes is located in the trust? I don't see it in mine. Lost the question, excuse me. Don't see it in mine, but do see something similar in my Ever plan. Please advise, thank you.
Thank you for that question. So a letter of wishes is something that does not have to be mentioned in the trust, but it could be. And so if it made you feel more comfortable to to say, I have provided a letter of wishes attached to the trust, and my trustee should reference that. There's nothing wrong with that. And I think another thing you might be referencing is that there is, in most of our documents, depending on when your document was created, we do have a memorandum of tangible personal property section in wills and trusts that says if I have a memo that I want to specifically control certain tangible personal property, then I'm going to attach that back to the back of my trust. So that's a whole different issue. But here's something to think about. We probably don't want, although we could, we probably don't want to mention a letter of wishes, because what we're trying to do is make that independent from the trust. Beyond the scope of this discussion today, what we're trying to do is establish our trustees' duties, establish the terms of the trust, establish all of the parameters of the trust. The memorandum of intent, or the letter of wishes, is really an independent thing that stands alone and can be changed, and is meant really to advise the trustee separate and apart from the trust. So I guess where I'm going with that is kind of a philosophic approach that says, I'm advising the trustee, I'm giving them all of my thoughts and encouragement and wishes, my intentions, my values, but I'm not directing them as if I'm controlling what they're doing in the trust. I'm just simply giving them further parameters that are practical, personal, value-based, emotional things that I want them to go by. So where I'm going with that is there's nothing wrong with saying I may attach a letter of wishes to this trust. Please follow that to the best of your intent, of your ability. But it's not necessary. And again, there's different schools of thought on this. My school of thought on it is that that's not necessary, but it may make you feel better to do that, so that you know there's a reference in the trust that there should be a letter of wishes attached. And if the trustee doesn't see that attached, then they need to look for it. So again, the idea is some separation between you as the grantor and the trustee, ideally, with this just being an independent memorandum, or you could definitely reference it. Again, it's just a matter of school of thought on that and the approach.
And last question, Steve, thank you. In terms of trustee record keeping for a special needs trust, what is different about records maintained for filing trust taxes and records maintained for compliance with means tested rules, for example, SSI and Medicaid?
That is a great question. So I'm going to try to answer that in a short summary. So when we're keeping records for tax purposes, right, we're just keeping good accounting, in my opinion. So we're, a good accounting with financial statements, and then there's various levels of accountings. There is what we call a national accounting standards level. So for example, we use a software called GEMS, GEMS, and that provides for a national accounting standard once we input all the information. Versus more simple accountings or Excel spreadsheet based accountings. So I think in answer to this question, a transactional accounting that's pretty straightforward. We can give you samples of this if you're looking for one. A transactional accounting on an annual basis. These are the income and dividends that have been earned. Here's a money market account that was earning interest. Here's where we started at the beginning of the year. Here's all the distributions. Here are all the items of income that are being distributed back to the trust from some source, like a refund of some kind. And now we get down to the bottom line. This is how much was distributed during the year. That kind of thing, that kind of record keeping is going to lend itself to good tax planning and record keeping for taxes, because it's going to show everything along with the financial statements. Where I'm going with that is the financial statements in and of themselves are not an accounting. So what I meant by that is the investment advisory statement. So let's say I get a statement from Charles Schwab and it shows all the transactions. Some trustees will just say, hey, there's my accounting. I'm sending that out to the beneficiary. So yeah, that's cheap and that saves a lot of money, but that's not an accounting. So what we're talking about is taking the information from a financial brokerage account or wherever the monies are invested or sitting, and then creating a real accounting for that. Now, for purposes of accounting for public benefits, what we're talking about is basically the same kind of accounting, depending on whatever level of accounting you're trying to provide, meaning it needs to be at least somewhat substantive. And we're talking about something above and beyond just a brokerage statement. We're talking about a software accounting of some kind or an Excel spreadsheet accounting of some kind. But now we need to understand that for public benefits, and this is something that most people are not aware of, people are concerned, well, my special needs beneficiary, they're on public benefits, or they're a qualified Medicare beneficiary. They're receiving some kind of benefit, but now the income from the trust is going to disqualify them. So what we need to understand from a public benefits accounting point of view, we're going to basically use the same accounting, but when we do the tax return and the income of a trust is actually attributed to a beneficiary, we need to remember that the CPA, or you, if you're preparing the tax return, you need to have a side letter that says, for federal income tax purposes, this special needs beneficiary did receive the X amount of dollars of income. But for Medicaid purposes and public benefit purposes, that X amount of dollars, whatever that might have been $10,000 worth of income, that is not income for Medicaid purposes. So that's something we need to understand. Many people live in fear that their loved one is going to be disqualified because of income from the trust. But for Medicaid and public benefit purposes, income from a trust, which is income for federal income tax purposes, is not income for public benefit purposes. And a side letter is going to explain that to anyone who wants to look at that accounting. Sorry, that went a little bit long in that explanation.
Okay, Steve, that's it for now. Thank you very much.
All right, so we're going to head toward the home stretch here. We've been going about an hour and 10 minutes. I just want to talk about the paths forward. So again, we want to educate. We want to be a resource to you. I thank you for your questions. That helps Jeff and I quite a bit through the presentation here this morning. But our Waypoint Trust Group is our division of Elville and Associates that does trust administration. And we also do accountings. If you're concerned about, do I have an accounting I need to do? What if I want to modify a trust? What if I need a trust protector? What if I need to terminate a trust? We can act as the independent trustees for trusts. So we just want you to know that that service is available. Some people want to have an alternative to certain corporate trustee relationships, but they still want an independent trustee. So we work with various banks and financial advisors, and with First State Trust Company in Delaware for the times when we need to use them for whatever our special purposes are. We also have a relationship with One Nevada Trust Company. So we can do all of those things, prepare income tax returns for trust. We can also advise you as a trustee. We can also help you if you want to kind of sift through the information about your trustee selection. If you're going through that thought process, we want to help you do that. So just know about Waypoint Trust Group. And again, we won't belabor that. But it looks like we're getting toward the end here. And again, I mentioned the trust protector. So I just want to end here in the last few slides with a bit of information about the trust protector. Again, this is not decanting. Remember, decanting is the power to completely change a trust and change it from this trust to a new trust. And there are situations where that's a good thing to do. There are also situations where that would be a very bad thing to do, and we don't want bad people using decanting for that purpose. The trust protector would be someone who is given independent authority to do certain things, and the trust protector might appoint a special trustee who will pursue the issue of decanting, but the trust protector would not do the decanting himself or herself. So the trust protector, again, is a special fiduciary. As background, the trust protector concept has been around, to my knowledge, about 20 years. It started in states like Alaska, Nevada, Wyoming, South Dakota, Delaware, Nevada. These places are asset protection states, and there's about 15 or 16 of those. And in those states, the trust protector has a special role because basically a person can self-settle an asset protection trust in those states, where you cannot do that in Maryland. But in now more routine planning, like Maryland planning, we've had trust advisors / trust protectors since 2014. And as I mentioned, it's a basic power of amendment. It's a power to make sure the grantor's intentions are carried out. Why am I going through all this? Is to make sure that when you select your trustee, that the trustee understands this role of this special fiduciary. Now, again, trust protectors are not required in all documents, although most of our documents today would include, with some exceptions, would include a trust protector, which can remove and replace trustees, direct trustees, mediate disputes. Let's say in a special needs trust or another trust where a beneficiary is vulnerable, the trust protector might have the power of compelling or demanding an accounting. So the role of the trust protector can be designed just like the role of the trustee. Now, in wills, trustees can be in these kinds of roles. So the trustee can be the trustee of a marital trust or a bypass trust, basically a trust for a spouse at death. So imagine a will, and where does a trustee fit into this? Well, at the death of one spouse, there can be a trust for another spouse. Sometimes there's no trust for a surviving spouse. So think of a trustee of a trust for a surviving spouse as one example. Maybe it's a marital trust, which many people have today, or maybe it's for the trust for a young beneficiary, someone under a certain age. That person is going to need a trustee. Now that trust under a will is going to be governed or managed by a trustee. What if there is a trust for a young person, but that trust does not end? Someone died, left a testamentary, irrevocable spendthrift trust. That's a mouthful. That just means a lifetime trust, in my opinion, for a beneficiary. This beneficiary is going to be the trustee of their own trust. We talked about that. Or maybe that beneficiary has a special trustee or an independent trustee, maybe co-trustees like one person asked about. So this is a trust that can last forever. And on as we could go to the different roles of trustees under wills. Now, similarly, the trustee role in a revocable trust is similar with one exception. The trustee of the living trust, remember the revocable trust is a trust during life, and then it becomes a trust at death. The trustee or the grantor of that trust is usually the trustee during their life or with couples during their joint lives. And then we have many of the same things. We have trusts at death created for spouses. So now there needs to be a trustee of that trust. There can be trusts for young beneficiaries, or there can be trusts for beneficiaries in general that are designed to last forever or for a certain period of time. So these are trusts, spendthrift trusts usually, that are created that last for a long period of time. Covering this again as we wrap up, reasons to consider appointing a corporate trustee would be their experience, their resources, their ability to manage assets without your individual trustee having to go out and find a financial advisor if that's not what you wanted. They are regulated. They are reliable, but I would put an asterisk beside that. I've had some corporate trustee dealings recently that weren't reliable, although vast majority of corporate trustees are reliable. They have objectivity because they're not family members. Again, they have resources. They may be a referral hub that can give you a lot of resources or your loved ones. And hopefully they are going to provide longevity. Hopefully they are going to be around for a long time. But remember, your trust protector can provide the flexibility that what if this entity that we thought was going to be around forever is no longer in existence, or they're getting ready to be bought out by another entity that the trust protector doesn't think is a good idea. The trustee can be changed. And for some people, it gives peace of mind. As we wrap up, why should you be concerned about one of my last bullet points in the beginning here, which was trustee risk, successor trustee risk? Well, what is the common thing that we hear in meetings? Well, The only people I have to appoint are my siblings, and they are my age, and we're all getting older. So, that is a problem for some people in their minds. On the other hand, I have noticed, and I'm sure you've noticed, that people are living a long time, and people have a lot of experience, many really qualified professionals that are retired, or family members that just have a lot of common sense. To me, there's no reason not to appoint these people just because they're older, as long as we've provided with a nice series of succession plans for successor trustees, for trust protectors for flexibility, or other flexibility measures. So people's health and does deteriorate over time. So this is an issue we have to be concerned about. Again, I think there's two things that can really help. Remember, updating and maintenance of plans over time. This is going to address a lot of the issues that pop up. So many of us want to plan forever. We do this in the conference room, and even I fall into this category. Sometimes we catch ourselves planning and saying, this is it. This has to be it forever. And that's a mistake. We want to plan as if it's forever, with the knowledge that the trust is flexible, or the will is flexible, and we are going to be flexible over time to update and maintain plans as we get older, and not fall out of a relationship with our estate planning attorney and just go silent and not update our planning for 20 years at a time. So Elville and Associates has a client care program. If you want to be a part of that, we strongly encourage updating. That's what it's all about. Yes, we have fun in our client care program. We just had an event with Boxwood Winery in Middleburg, Virginia, where a lot of people enjoyed a wine tasting. Yes, we have a lot of fun. We do social events like at theaters and other things when that's allowed again. But what we're trying to do mainly with our client care program is encourage people to update. That's the whole thrust of it. If you update over time, and if you stay open-minded, you will not have this problem of successor trustee risk, at least in the design. And then after our passing, if we've built in enough flexibility, we know we're doing everything we can to mitigate that risk, along with educating beneficiaries. So we want our trustees to be the best they can be. We want to plan for a long period of time, but we also want to stay vigilant to update and maintain plans. Life changes, divorce, creditors, bankruptcy, disability. What if someone has a car accident? They're a wonderful person, a wonderful trustee, an individual trustee, but they have now become injured and they can't act. This is where the flexibility needs to be in the plan, and that is something that you update over time. You use trust protectors, you use letters of intent, you do all those things. What if the trustee becomes disconnected with the needs of the beneficiary? What if there's a beneficiary who needs this connection, but the trustee is not connected? And what if the trust protector has a passive role? This is something that can be designed into the planning. I don't want that disconnection. I don't want the trustee and the trust protector to not be talking to one another once a year. This can be part of the design. What if the beneficiary is very demanding? And what if the trustee says, the heck with this, I'm not going to put myself in this position where I'm the trustee. This person is extremely demanding. I can't keep up with this person. They're making my life miserable. Again, we can't control the future. We can only control the design. And if the design is flexible, the trust protector would be able to deal with a trustee who wasn't going to continue to serve because of the demands of the beneficiary, or the trust protector could mediate and try to play devil's advocate there to fix the problem with the beneficiary. The trustee has to be willing to serve. They have to have the fortitude to serve, and they have to have the perseverance to serve. And that's something that Jeff and I probably should include in those three circles, that willingness, fortitude, and perseverance are sometimes required as trustees. So that's a risk. If they don't have that fortitude, trust protector can replace them or their successors that are well designed. Trustee compensation. We have to provide, at least in theory, for some reasonable compensation, or trustees may not be willing to serve. We probably don't want to limit trustee compensation with statutory-based compensation or other language that would limit the compensation. On the other hand, we have to have some assurance it's going to be reasonable, and that can be designed into the plan as well. So we're about at our end here. I've gone almost an hour and a half. Thank you for your patience. We want to encourage you that there is a path forward, that there's next steps. Set an appointment with us to discuss appropriate selection of trustees. We want to review all options and help you. We want to advise you. We want to counsel you. Consider Waypoint Trust Group if you want an independent trustee and you don't want to go with a corporate type trustee relationship. Take action to implement and update the changes in your planning. I know that from what Jeff told me, 60% of you on this call already have done planning, or you're a grantor of a trust at some time in your life. Make sure you plan and update over time. Make sure you stay educated so you know what the flexibility options are, and take action immediately with trustee choices in either the end of this year into the new year, and interview people and really get to know what it is that you want. And if you have trustee selections already, you could take steps to make sure they become educated and that you're getting a sense of their commitment from the outset. So as we close, and I hand this back to Jeff, Jeff, I don't know if you're doing a survey today, but I just want to say to people on the call, if you want to contact me, please do at this information here. Please contact Jeff at jeff@elvilleassociates.com. Please contact Mary Gay Kramer if you would like to set appointment with me as well, mary@elvilleassociates.com. And again, we thank you for taking the time, and I think we're ending just about at an hour and a half, and hope you have a wonderful weekend ahead. Don't be shy if you have further questions here at the end of the workshop. Jeff, I'll turn it back to you.
Well, thank you, Steve. Right on time. And for those that do have any closing questions, now is certainly your time to get those to me. As I offer just a couple of closing comments, thank you, Steve, for a job well done, a very spirited presentation today. And thank you to you, the attendees, for your questions and your participation. Please do take a few minutes to offer your thoughts and your feedback in our post-webinar feedback email that's going to be coming out. I'm also going to stay online for a few minutes if there are any related questions, non-legal questions that you want to post to me afterwards. Also, we have a few excellent webinars coming up in the next 2 weeks. Next Tuesday, we have Lindsay Moss offering a discussion about VA aid and attendance. This is a new presentation. Next Friday, Steve is going to be back talking about what families need to know about planning for a loved one with special needs, always a very popular discussion. And a very special treat we have on November 5th, Ellen Platt, a very high-level certified geriatric care, life care manager, coming in to talk about COVID-19 and mental health. I had a preview of this discussion this Tuesday. I looked at and saw the full presentation. It is certainly one you do not want to miss. Very timely and important discussion. So I encourage you to sign up for that. Also, anything else I want to talk about? Let me see if there's any other questions. We have some questions about the client care program from some clients. I'll be sure to get that information out to you. And we do have another question here for you, Steve. So that question is, let me get to the top of it. I also referred, let's see here. Oh, actually, it's from an advisor regarding somebody that they want to have you speak to. So I'll send that to you privately. So thank you very much, Barbara. We appreciate that. So without anything else, if there are no further questions, we thank you for participating. We look forward to hosting you again soon. We hope you have a wonderful rest of your Friday and a great weekend. Have a great day, everybody.
Thank you.
I will stay on for a few minutes if there are further questions.